9 women defendants of the Money Rebellion offshoot group of Extinction Rebellion have been acquitted of what's reported to be £500,000 worth of criminal damage to the windows of HSBC headquarters in London, despite being filmed in the act. Many of you have asked why this is, what possible arguments there could be, and so I'll go over a few of those in this video. But first of all, let's take a look at that video. This is them being filmed in the act. Now, anyone watching can see that there's no ambiguity that they are smashing these windows, or at least attempting to in some cases, with these hammers and chisels. Now, there's no need to play the rest of it, but eventually they sit down and start singing. Now, they all went to the Crown Court and they were each acquitted of criminal damage. And many people have quite rightly asked why this is, and surely this means the justice system doesn't work, and if there's a crime so clearly committed, surely that means the system doesn't work, and so on. But let's explore one or two of those possible arguments. Let's go back in time to the Colston Fall, where they tipped the statue, the Colston statue, into the water. Now, their argument in that case was that the statue belonged to the people of Bristol and that they would have consented. And of course, if someone genuinely believes that the owner of property would consent to the damage and the jury accepts that argument, then it's not criminal damage. Now, whilst I don't know the exact arguments that will run in this case, it is reported on Garden Court Chambers website, which was the set of barristers that defended these women, said that they had lawful excuse for their acts. Now, I'll come back to the jury's role in this in just a moment, but let's look for a moment at what lawful acts might be in terms of criminal damage. I've used the example before on this channel. If it's a hot summer's day, you walk past a vehicle, it's blisteringly hot, you see a dog or a baby or anybody for that matter in the vehicle, and you believe that they are not going to survive because it's too hot. If you genuinely believe that the owner of the vehicle would consent to the damage to free them and save their life, then it's not criminal damage to break the window. Of course, you're advised to ring the police and the RSPCA and everything else, but most people, most reasonable, sensible people probably wouldn't think it's such a bad thing to smash the window, save the baby, save the dog, instead of wasting time waiting for someone else to come and do it for you. So in that case, that would be a lawful excuse because you reasonably believe the owner would consent to the damage. Now, there are other aspects that might also amount to a reasonable and lawful excuse in this situation. For one instance, there might be prevention of crime. For example, a defendant might argue that it's necessary to cause this damage to prevent more significant damage. For example, breaking a door to rescue someone inside, just as in the vehicle example. Causing damage to the door to break into a property to save someone's life obviously is going to be deemed lawful because you're saving their life. Also, if it's acting in self-defense, if you damage something and it's in the act of self-defense, then it might be considered a lawful excuse. Likewise, you might be protecting property. In some instances, there might be an official authority where the authorities destroy illicit substances. For example, it isn't criminal damage to destroy something when you have the legal authority, official authority, to do so. So in this case, you might well be left confused because none of those amount to a lawful excuse to commit criminal damage. Although the defendants in this case said that they were morally justified in causing that damage in protest, because they say it was in protest of HSBC investing £80 billion in fossil fuels over the last 5 years since the Paris Agreement. And so now many people have asked, is it possible to appeal this acquittal? Well, ordinarily, no. There's only one narrow exception to appeal an acquittal, and that is usually based on new evidence. Section 76 of the Criminal Justice Act 2003 provides for a 3-part test. First of all, there must be evidence which was not originally before the court before, which represents compelling new evidence that might alter the outcome of the case. Secondly, it must also be in the public interest for that application for a retrial to proceed. And thirdly, and rather importantly, that it would not be inconsistent with the obligations in the UK against being tried twice for the same offence. And so it seems relatively unlikely that there's going to be any new evidence, and therefore unlikely that this application is going to be made. So some people might then think, well, why can't the prosecutor hold back some evidence in order to use it in one of these applications? Well, that's not possible either, because all of the evidence that's available to be used or that goes unused must be disclosed under the ongoing duty of disclosure. And that includes everything. And if anything is not disclosed, and that in and of itself could be used in an appeal even if they were convicted. So this once again throws up the debate as to whether or not we should retain trial by jury, because this is what we refer to as a perverse verdict.
So jury nullification has got this air of mystery around the term, because many people say that we as barristers can't talk about it, which is strictly correct. So why am I talking about it? Well, this isn't a courtroom. This is my gym here. If it were a courtroom, and during COVID we were doing trials in lockdown, and so this effectively became a courtroom from where I was practicing law, I would not be allowed to mention jury nullification. Not that we would have had a jury in here or remotely like this. I was doing civil trials, but nonetheless, if you are in a trial as a barrister, you cannot mention jury nullification, because it would be contempt of court to do so, because it would tempt the jury into making a decision that goes against the law and the findings of evidence, which is against their oath that they take as a member of the jury. So, with that out of the way, let's explain what it means, and then it'll probably become clearer as to why we cannot talk about it and why it's contempt of court. So when you are called upon to do jury service and you are in the courtroom, and let's say the defendant hasn't given any reasonable objection to you sitting on that jury, you then take an oath before you can carry out your duty as a member of the jury. That oath is as follows: I swear by God of your faith, or I solemnly, sincerely and truly declare and affirm, which is the affirmation, that I will faithfully try the defendant and give a true verdict according to the evidence. So that's the key part there. According to the evidence, you are making a promise to the court, and either to your faith or an affirmation to the court, that you are going to try the defendant only according to the evidence. And what this essentially means is you cannot try the defendant, i.e. come to a guilty or not guilty verdict, based on anything else that you've heard or read about. You cannot research the case. You cannot talk to other people about the case. The judge will be very clear and very strict with you that you must not discuss this outside of your jury number and outside of court. In fact, there have been cases where jury members have been brought to prosecution for contempt of court and been sentenced to 6 months in prison because they've revealed what was being discussed inside the jury room after when they were outside of court.
I.e., there is an obvious scenario here where somebody has, on the face of it, broken the law and caused a significant amount of criminal damage. But the jury, on the other hand, came back with an acquittal. Now, I've heard all sorts of comments such as the judge should be held liable, the judge should not accept the jury's verdict, and all of these sorts of things. But that is not how it works. A trial by jury is exactly that. The jury is the finder of fact. The jury is not required, and indeed not even permitted, to give the reasons for their verdict. Their verdict is what it is. Only in situations where there's evidence of interference with or intimidation of a member of a jury or a witness or something like that, the High Court might in those cases make an order quashing an acquittal and ordering a retrial. So as I said, this usually gives rise to the debate as to whether or not we should retain trial by jury. The only alternative really is trial by a single judge or a panel of judges, much like we do in the magistrate's court. Thereby it's either a single or a panel bench. But I'm sure there'll be lots of further questions and comments. Please do leave those below. This is obviously a very difficult and detailed subject, which I can only really brush the surface of in a few short minutes. Happy to look at further aspects of it and do more videos on it. And thank you once again to everybody that's been over to Black Belt Secrets. We've now tipped over 100,000 subscribers, so thank you all very much for that. And of course, thank you for watching.